Good evening, everyone. Good evening. Sorry, we're starting a little late because some late arrivals here and there. First, I want to congratulate everybody for being able to be here tonight because of our very special guest, Dato Seri Hishamudin Yunus of wide fame. He is a man who has actually written 700 judgments in his life, which is, well, that's quite some doing. And some of the judgments are what makes up this book that we are introducing to you today. And the title, of course, is wonderful, straight to the point. It's the least, it's what everyone wants in Malaysia, right? Upholding the Federal Constitution. And once that is upheld, I think things should fall into place for Malaysia Madani. So I won't say more. You're here to listen to Dato Seri. Let me introduce then our favorite moderator, Gareth Richards, who's kindly consented again tonight to moderate for us. Despite his very, very busy schedule editing global books, as it were. Yeah. So Gareth, I'll leave the floor to you. Thanks again, everyone, for coming.
It's funny when Kee Beng starts with a little white lie. Our favorite moderators, there's no favoritism in it. When they can't find somebody else to do the job, I get the call. So this is what my third appearance this year, and we're only in February. Anyway, Happy New Year to everybody for the Chinese New Year. And yeah, thank you very much for coming out on Friday night. And honestly, for me personally, and I'm going to say politically, it's a huge honor to be able to moderate this event. And in fact, the invitation didn't this time come from Kee Beng and Penang Institute. It was my dear old friend, Dato Anwar Faisal, who, let's say he was very persuasive. But actually, once he said, you know, there's a new book out and it's on Dato Seri Hishamudin Yunus's, you know, legal career, and it's a critical reflection on some of the major cases that he's participated in. Then for me, it was a no-brainer. I mean, I really wanted to do this evening. Later on, I'll tell you a slightly quirky coincidence that actually links Hisham and myself, much to your surprise, I'm sure. But to kick off proceedings for now, I would like to invite Dato Anwar Faisal to give some brief introductory remarks. Please welcome Dato Anwar Faisal.
Thank you, Gareth. As you know, you'll have to endure me for a while. Dato Seri Hishamudin Yunus, our speaker. Dr. Kee Beng, our host. And of course, my dear friend, Gareth, with whom I share a life. We are both bibliophiles. Yeah? He sells and I buy, you know, so it's a wonderful relationship of sharing something so beautiful. Welcome to this very special place, Penang. It's got itself very interesting stories. You know, Penang Institute, as you know itself, is a place which has the initials PI, and I very often describe it as public interest. Yeah, that it is an institute that's actually bringing out thoughts and ideas and sessions where we interact about great ideas. And it's this kind of public interest that very often is lacking in this country because we don't find the kind of critical thinking with critical speakers. We also welcome Dato Seri and many of our dear friends here to Penang. We are, as I always describe, a kind of Pasombor, a kind of roja of people, places, and passions, and also different kinds of chilies and sambals, and including one of the world's most iconic chili sauce, which is over a century old. And I was planning to bring one bottle for Dato Seri Hishamudin. I found that my wife had already opened it and used it recently. But I will try and arrange to give him a bottle of Lingam's chili sauce, over a century old, and Penang's first major product, to share with the world, made out of recycled pear and parings, Worcestershire sauce, we got recycled bottles and made this chili sauce that became so global and got the British addicted. That's the only thing we can get them addicted to very often is chili sambals, that kind of things. Our country, Malaysia, of course, is, as already mentioned, we are such a complex place, but a kind of I would say a wonderful, magnificent complexity. So complex that actually, like all the different kinds of natural things and so on, we live with each other. We have our quarrels, like we have our family quarrels, and we occasionally then settle down, and then we even love each other more after we quarrel. It's just one of those strange countries which very often people don't believe could exist. We had such a complex system of governance, which is in some ways even glued by a monarchical system, which itself has got a very unusual history. And there is a expectation, of course, that in such a place it would not have lasted very long, but people are just shocked about the things that happened and how we grew and grew and grew. We are also, Penang is also the first place. I wanted to tell Dato Sri also about legal personalities in Penang. The first magistrate of Penang was charged for corruption and dismissed. This is about 2 centuries ago. So we have an interesting legal history, where we started off our legal history by actually removing the corrupt judge instead of having a judge that actually would be dealing with this matter. And then also it was from Penang that we also did only the British, any British here? Or maybe English, I can't remember, who have such a beautiful command of English that they can make any word mean anything. And they entered from Penang. We went over to Perak, and had the Pangkor Agreement, and we made them gently as usual and said, you are going to be destroyed and other people make your life mess. Why don't you sign an agreement with us? And we will help you, to move on. And the agreement said, we will only be your advisors. But our advice must be asked and acted upon. Oh, advice must on all matters except those concerning the Islamic religion. You can do your prayers by yourself. I don't know whether there's a word for this, but this is a kind of linguistic deception that I think is very often judges and so on have to really deal with difficult words that people use because everybody says I meant something else. I wasn't insulting you. I was actually saying nice things about you. We saw, of course, this wonderful structure, but moved from 48 to 57, and then, of course, to 69 when we had a spectacular downfall suddenly of how we were moving forward, that kind of shock. And out of that emerged the Rukun Negara. which was a wonderful thing, including some adjustments and so on about new kinds of ways of working together as a family. And the Rukun Negara itself as a document, very often people only remember part 2 about belief in God and the suspects, but they don't read the first part of the Rukun Negara. And the first 5 principles are actually the essence of all the democratic and other values that we have that we are supposed to observe. And then in our pursuit for that, of course, we are going to be nice to everybody that we have to be nice to, considering that we are such a complex. And it's nearly 40 years ago that a conference was held, a conference on the Constitution, a national conference on the Constitution, which is just remarkable. And the papers carried 2 full, that time the papers were that big size, with a full speech of the Sultan of Perak, that time Raja Azlan Shah. And it's interesting that he spoke in detail about the Constitution. Just 40 years later, his son launched your book and spoke about the Constitution. It's very interesting that we have also monarchical traditions of people who really speak out about what the issue. And he made one strong statement, and he said, look at our Constitution. One of the big failures is that we have not incorporated the Rukun Negara into the Constitution. And because we did not do that, we didn't capture the essence to be part of our legal framework. So that when we look at that beautiful statement about how we should be dealing with each other. And sadly, of course, it's done. And one thing, of course, the government was consistent with for a long time, which again is one element about upholding the federal constitution, is the power of the government with the Internal Security Act, and how that has been ruthlessly used. That was the kind of underside of this. We know now there has been a bit of rethinking and a softening of that process, but it's really, again, one of the black sides of our constitutional process, and fortunately, this is changing. But we have a wonderful person who's seen this journey going, who's written about them, who's had to deal with all the complex issues that I have talked about, and he's always dealt with them, and that's been one of my admiration of him, and always with a kind of competence that is so important, a kind of conscience that always he's thinking about the decision has to be properly done in that, and with wisdom. That is, you also capture what this is going to have as a consequences. And I think of when I think of him, I think of 2 very special legal persons in this country. One was Tun Sufyan Hashim, who was a very remarkable legal person who published a book nearly 56 years ago, and I was very close contact with him. And he explained a great deal in an introduction to the conference, and I did a lot of my learning from him on this particular issue. The other was someone, again, that's too easily forgotten, who was Yusufi Abdul Kader. Amazing lawyer who stands up to things. I had the pleasure of, nearly 60 years ago, when I first started work, he was the lawyer of the City Council of Georgetown, and he was working for this very prestigious firm with 2 European names on it. And he had a timer on his table. Every time he sees somebody, he puts a timer on, and then he charges you based on the time that you have taken. I mean, what advanced technology had 60 years ago. But because he was such a disciplined person, you have a problem, he answers it to you in minutes and tell you, this needs to be done, this needs to be done, get this done, this did apart. And then he gives you the answer. He's not the lawyer who will sit down there and have a 1.5 hour chat, with you, trying to explain all the problems and so on. Very firm, very quick. And, we sadly lost him, but he was a great personality that I think from time to time we must talk. He was also among those persons who spoke up and who suffered from the surgery done by a political medical doctor, yeah, in there, where judges had to go through a really horrible period, which again we learned from on how to protect our judges and not allow them to be treated like the way that they were treated, like animals that were herded up and thrown away for some time. Well, fortunately, we have someone who can share, the way in which he worked with that kind of really discipline and caring. So thank you so much, Dato Sri. Great pleasure to have you here, and we look forward to hearing from you. He likes to make judgments, but he doesn't like to make speeches. Yeah. So he said he will be brief in his speeches, but he's going to enjoy the conversation and sharing his journey over many of these things together with Gareth. Thank you very much, and Assalamu alaikum.
I think it's probably likely that Anwar also charges by the minute with a timer as well. So we come to the main part of this evening's event. Although Anwar talked about the crooked magistrate, of course, Penang in the archipelago, was the foundation of the modern legal system in the whole of the Malayan archipelago. The first court of judicature set up in 1807, and at least three major personalities I'd just like to touch on. James Logan, after whom a famous public lecture is named, a progressive Scottish lawyer of the mid-19th century. P.G. Lim, first woman to be called to the bar, of course, coming from the very celebrated Lim family. And lest we forget Kapil Singh. So Penang, and this room is also full of lawyers, I believe. There are several of the legal fraternity here with us tonight. So I think it's very appropriate, I think, that Dato Sri has come here to share his thoughts in this particular and special place. Now, I said in my introductory remarks, we have this strange and slightly serendipitous connection. I know some of you will find this rather unbelievable, but for 4 years, from 2005 to 2009, I worked in Putrajaya, and you'll never guess where. Jabatan Peguam Negara, saya. I know it's really unbelievable. So I was talking to Dato Sri before the gig, and I will tell you something. Among those within the AG's chambers, whether it was particularly from legal reform department and the advisory department, Dato Sri was already a High Court judge, but his name was spoken of with a certain degree of reverence that was not given to all the senior judges, so that he carried within him, even within the AG's chambers, and some of the older colleagues also remembered his own time there. And so I think that's, in a profession that's remarkably fractious, lawyers like to argue by definition, that's why they get paid. Dato Sri's name actually carried a certain resonance and a mark of the man himself. I think I'd just use my introductory remarks to give you a sense of an overview of the life for those of you who don't know this. This is quite nicely captured near the beginning of the book. But born, am I allowed, is it correct to tell the date of birth of gentleman? It is. Born in 1949 in Negeri Sembilan. In some ways, Dato Sri had a fairly conventional education of men of his class and distinction of the time. I mean, he did his secondary education in MCKK, Malay College in Kuala Kangsar, and then went off to, well, it wasn't quite swinging 60s London. It was the 1970s to study law at the LSE. And indeed, he went back later and did a postgraduate in law at the LSE. And then he joined the Malaysian Judicial and Legal Service also in the 1970s, a very interesting period. After all, the country was just going through the kind of post-May 69 adjustments, and that included major and fundamental structural changes in the law, some of which still resonate down to this day, 50 years later. And so, you know, he worked in the judicial and legal service in many different capacities. President of the Sessions Court. He was a Selangor State legal advisor. In chambers, he was the deputy parliamentary draftsman and chief registrar of the Supreme Court. So, you know, there's this very long and distinguished record of public service and so on. I guess for us, when we were working in chambers, it was his appointment as a High Court judge. So that was 1994, almost 30 years ago. And this notion that here was this extremely principled, somebody who created judgments that were based on a very clear understanding of deep principles in the law. And that was established very early on, and it became the hallmark, I think, of an entire career. He was elevated to the Court of Appeal in 2009, which is when I left Chambers. It was that year. When Najib came to office, I left. The two things may or may not be connected. I leave that to you to decide. And then he retired from service in 2015. And I have to say this, having never been elevated to the federal court. And there's a story in that, and I'm sure Dato Seri will allude to that story. Since that time, of course, besides being a consultant in private practice, among other things, he's been a member of the Judicial Appointments Commission, and also very notably at the SOHAKAM, the Human Rights Commission, and so on. So that's the resume, and it speaks of service. It speaks of a set of principles which were then applied in his professional capacity. But what of the man himself? And I was very struck by some of the endorsements in the book, and particularly this one from Shad Faruqi, Professor of Law at my old place, University of Malaya. I just want to read this to you as a way of introducing Dato Seri to you. His years on the bench were marked by integrity, fearless independence, and an unwavering commitment to constitutional supremacy. And I love this phrase. He showed tenderness. It's not a word you often associate with lawyers. He showed tenderness for fundamental liberties and exhibited a creative and activist streak in his interpretation of laws. He will be remembered with respect by all those who believe the judiciary must balance the might of the state with the rights of the citizens. Please give a very warm Penang welcome to Dato Seri Hishamudin Yunus.
Thank you, Dato Seri Anwar, and the girl for all those kind words. Dato Seri Anwar says, I will have to give a short speech. So I have penned a few of my thoughts on paper tonight. Dato Kui Beng, Executive Director of the Penang Institute. Dato Seri Dr. Anwar Fazal, Moderator Gareth Richards, ladies and gentlemen, Salam Sejahtera and good evening. It is indeed a great pleasure to be with you all this evening. Thank you for coming. May I begin by expressing my profound, heartfelt gratitude to colleague in G25, Dato Seri Dr. Anwar Fazal, for his kindness in initiating and organizing the launching of the book Upholding the Federal Constitution here tonight at the Penang Institute. I also wish to express my utmost gratitude and appreciation to Mr. Gareth Richards of Gerak Budaya for his kindness in being the moderator for this event. Thank you very much, Dato Seri Dr. Anwar Fazal and the Penang Institute for giving me this opportunity. I'm indeed touched and humbled. As a matter of background, the first launching of this book was on the 14th of December last year at the Sofitel. The launching was graced by His Royal Highness, the Yang Diputan Besar of Negeri Sembilan, Tuanku Muhriz Ibn Al-Mahrum Tuanku Abdul Rahman. The event was also graced by the Right Honourable Chief Justice, Yang Amat Arif Tengku Maimun Tuan Mat. About 30 judges attended the function, and many from the legal fraternity also attended. Now about the book. I wish to thank my firm, Rosli Dahlan Saravana Partnership, from the bottom of my heart for investing a great amount of resources, time, and effort in coming up with this book project. In particular, I wish to thank senior partners Dato D.P. Naban and Encik Rosli Dahlan for supporting the project, as well as Mr. S. Saravana Kumar, the partner cum editor directly in charge of the project, whose determination and untiring efforts have ensured the timely production of the book. I would also like to thank a partner and an associate from my firm, Mr. Chia Tai Lung and Ms. Jia Hui, for being here with me tonight to give me moral support. I also wish to express my gratitude to the partners and associates of my firm who have kindly contributed their commentaries that make up the contents of the book, as well as to the staff of the firm involved in the book project. Ladies and gentlemen, it is indeed a great pleasure to have all of you here today. I believe we all share the common purpose of celebrating the upholding of our Federal Constitution and the judicial independence. Let me at the outset declare that I am not the author of the book. The book consists of critical commentaries by the partners and associates of my firm, Rosli Dahlan Saravana Partnership, focusing on my judgments on fundamental liberties and the Federal Constitution. These judgments are judgments that I had delivered whilst on the bench over a span of almost 23 years. The 15 chapters in the book discuss critically my judgments, and of course, it goes my thought as well, on freedom of speech, freedom of movement, freedom of religion, rights to property, rights to equality, native rights, rights to life and liberty, rules of natural justice, and other themes on the Federal Constitution. Ladies and gentlemen, over 2 decades of judgeship, the judgments that I made were but my modest contribution towards upholding justice for the happiness of our society. I consider the judgments that I made are part of my duty to uphold the Federal Constitution, to uphold justice, and to uphold judicial independence, and also to uphold my oath of office as a judge. In my personal experience on the bench, to be consistent and to fiercely uphold the rule of law and the independence of the judiciary. In whatever circumstances, it is not without challenges and sacrifice. In this regard, my family, especially my beloved wife, Siti, all of whom have been supportive and have stood by me in whatever situations. Tonight, may I take this opportunity to say that I am a bit optimistic that with strong awareness of the importance of an independent judiciary and fundamental liberties and the very recent change in the political landscape of our nation, a change that we have been waiting for so long. Things will change for the better in this country. Let's pray. I'm confident that the new leadership in the judiciary, with the Right Honorable Justice Tunku Maimun Mat, Tuan Mat at the helm, will restore public confidence in the administration of justice in this country, and that the judiciary will function in a better environment than before. Tonight, as we celebrate the launching of our book, let us not forget the judicial, as mentioned by Dato Seri Anwar Faisal just now, let us not forget the judicial tragedy of 1988, when 3 highly respected judges were unjustly dismissed and 3 highly respected judges were unjustly suspended by the political powers then. The 3 unjustly dismissed, let me give them their names. Tun Saleh Abbas, Tan Sri Wan Sulaiman, and Datuk Josia. And the 3 suspended, Tan Sri Wan Azmi, Tan Sri Yusfi Abdul Qadir, and Tan Sri Wan Hamzah. The dismissals and suspension of the 6 innocent and courageous judges were acts of political brutality and cruelty. This judicial tragedy left a black mark on the history of our judiciary. After that unfortunate event, our judiciary took a downturn and there was a culture of fear. Hopefully today we are on the way to recovery. Be that as it may, we must never ever forget such a tragic episode. As always, there are lessons to be learned. But whatever it is, all Malaysians must never ever allow such a horrible thing to ever happen again to our judiciary. Ladies and gentlemen, as we stand here today, there are already a number of seminal pronouncements by the Federal Court, such as the Doctrine of Basic Structure, the Doctrine of the Separation of Powers, Upholding Fundamental Liberties, the unconstitutionality of ouster clauses that has been littering our legislation, judicial independence, and the judicial power of judicial review. All these judgments bring about a much-needed breath of fresh air. They must be applauded and celebrated. It has been inspiring to witness these judicial developments. I'm sure they fill us all with a lot of hope. These developments are significant as they bring life and meaning to the citizens' expectation of justice and are in accord with the rule of law and the spirit of the Federal Constitution. They are manifestations of judicial activisms by enlightened and courageous judges. They instill public confidence in the judiciary, the last bastion of protection of the people's right. I heartily commend the federal judges in these cases for upholding the Federal Constitution. I earnestly hope that these developments will inspire all judges, lawyers, and law students alike to uphold our Federal Constitution without fear or favor. Finally, I hope everyone will find the book useful and enjoyable to read. Thank you.
Thank you very much, Dato Seri, for the very touching words, I have to say. So let me just talk you through the structure. We're going to be in conversation for a little while, reflecting not only on the book. I'm going to be asking Dato Seri about the life, because I think it's in many ways the life well led has also informed the deep principles that are contained in the critical essays in the book. And then we'll round off with actually a little ceremony to actually officially launch the book. But before we get into it, and I have to say, although I'm not a lawyer, I actually have read this from cover to cover and found it really, really fascinating. But I do want to begin just with the life, Dato Seri. Young man, coming of age at MCKK in the 1960s. So you were that immediate post-Merdeka generation. Looking back at that time, what were your hopes? What were your aspirations as a young scholar at MCKK?
I have no really, very high aspiration as a student. My aspiration was merely to do what my parents want me to do well in school and get to university.
And did law feature, or when did law raise its ugly head? I'm sorry.
I'm not really sure that I really wanted to be a lawyer.
So you say you fell into it by accident.
I applied also to apply for social anthropology, scholarship, but I didn't get it. And I was for a while at the University of Malaysia doing economics. Yeah, because in UK the course law starts in September. I applied for the scholarship, but I'm not sure whether I'm going to get the scholarship. So I went to University of Malaysia. At that time, we didn't have a law faculty. So I enrolled for economics. Yeah, and then September came, and I succeeded in the scholarship to do law. But I have to be honest, yeah, I think I want to go more to overseas, especially the United Kingdom than to do law. Yes. Yeah, that's how I end up doing law. But I went to the right university. Went to London School of Economics. Yeah, it's a socialistness. Yeah, but I think it's the way that my professors just taught me the law that I fell in love with the law, and then I developed this aspiration that one day I ought to be a judge. Yeah.
So social anthropology's great loss was obviously law's great gain. So the year we're talking about when you went up to LSE was 68, 69?
69, September.
September 69. Now, what a context. So just 6 months before you went off to the UK to study, we had the events of May 69. How did those affect you? Did they affect you at all as a young man? You were aspiring to the law. You were about to go to an institution, as you said, which had a rather left-wing or progressive reputation at the time, and indeed still now. How did the political atmosphere in Malaysia at the time, when we had the suspension of Parliament for a while, we had a raft of new, fairly draconian legislation put in place? What were your own reflections? I'm not saying immediately, but even during the years when you were away in London.
Right. Why did I apply to go to LSE? At that time, there were student unrest all over the world. There was in US it was Berkeley, UK was LSE, and France was Sorbonne. So because of the social student unrest, our Straits Times then have a lot of coverage on LSC. Every center page is LSC. So that's why it made me to apply to LSC. But when I joined University of Malaya, that was in May, I joined today, the May 13th tragedy erupted in 3 days later. Yeah, so we were all barricaded I was in 5th college, originally from University of Malaya, 5th college, I was in 5th college, just very new then. So we were all barricaded, we cannot go out, yeah. Yeah, so they were burning and looting in the city of Kuala Lumpur. Some death, yeah. And we're not supposed to go out, yeah. We were given porridge to eat. I was a bit very naive then. I wasn't thinking about. I never think about big things. I wasn't interested in politics at all. Yeah. Dr. Mahathir, I remember, came to the campus, with this special letter, Dr. Mahathir's letter, yes, meeting us students there. But I wasn't interested. So when I went to UK, I was very naive about politics, very naive. But one thing I remember, before we left for the Kingdom, a few days, we were briefed by the special branch. Yeah, my batch. And among the batch, the names, I can remember Tan Sri Arif, who later became the speaker, my batch. Tan Sri Apandi, who became AG, Federal Court, Tan Sri Hamid Mbo, and who else? Mr. Hira Singh, Dato Hashim Yusof, who later became Federal Court judge. So we were in the same batch, same scholarship. We flew on the same night, on the same plane, Qantas Airline. And we took off. There's no Subang Airport then. No Subang Airport. We took off from the old Sungai Besi. That was our airport then. Yeah, Sungai Besi Airport. Yeah, which doubled as an Air Force. Yeah. So, special branch came and gave us a pep talk. He says, we have to let you know what to expect when you go to London. Yeah. A lot of Malaysian students went up there and they became socialists, very anti-government, and they neglect their studies. So we don't want that to happen to you. So we have to warn you, when you are there, be careful not to be influenced by these elements. Yeah. They will try to befriend you because you are fresh. You have problems getting your accommodation. You might even have financial problems. They will be there to help you. To help purposely to help you. And then they will slowly influence you by lending you books on socialism. Yeah, that's the briefing that we have got then before we took off for London. Yeah, and rightly when I arrived there, the same thing happens. Of course, then I was prepared. So I wasn't really that being influenced. But I must tell you, yes, I think I was young and ideal. I was influenced by socialist idea. Yeah, I was an extreme socialist then. Yeah, yes, right.
Excellent, great stories. I've edited a lot of memoirs actually of people from that generation, 60s and 70s and so on. And the stories they tell really do resonate with your account just now. But tell us a little bit about the legal training that you had, both as an undergraduate and then later as a postgraduate, also at the LSE, and how that legal education began to shape the kinds of ideals and principles that you would later apply during your professional service. As a former university professor, I'm always interested in that process of transference of the learning skills and knowledge and expertise into the later professional life.
Well, I owe it a lot to my professors and lecturers at the LSC for what I am today. Yeah. It's the way that they taught me the law. The way they taught me the law, that makes me love the subject, right? And then I have notable professors, Professor Wedderburn on company law, Professor Griffith on administrative law, Professor Hartley. These are the names that I can still remember. Well, I owe them for what I am today. You know, the way they taught the law, it makes me, fell in love with the law. Then they're very strict. They're very strict. It's a small class of 30. I think in that class of law then at LSC, only a small class, and there were only 3 Malaysian students. Yeah, they're very strict. We have to read the cases for tutorials. Yeah, in a class, and they'll give you notes, all the cases to read, all the list of cases, and you must not read the head notes. If a law student here, no, don't read the head notes. You have to read the judgments of the individual judges, what Lord Macmillan said, or what Lord Denning said, what Lord Atkinson read. You have to read the judgments, and tutorial. Question you will be asked. I'll be asked, and my tutor will call me. He'll call me. He won't call me Hishamudin or Hisham. He'll call me by my father's name, Mr. Yunus. What do you think of judgment of Lord Macmillan in that? And if I say I'm sorry, sir, I didn't read that. Oh, you're going to get it. I got it. Yeah. Next time, don't be a passenger in my class. Yeah. Wow. Yes, and there was one Professor Griffith, administrative law. He asked us to read the government. He came to the class. Yes, all of us to read. He came. Have you all read the paper they asked you to read? None of us read. And he just walked out of the class. Right. Okay. Yes. But I enjoyed my course there. It's a 3 years course here.
No, wonderful stories and that sense of discipline. Griffith's work I actually know quite well of your old professors. Let's move ahead a little bit. I mean, you had nearly 4 decades in service, starting in as a magistrate, by the way, and the first job, a magistrate in Kuala Lumpur, I believe. But if we come to the substance of the book, now, as Dato Seri said, so there's no illusions about what you're all going to buy afterwards. The book is not by him, although he writes very eloquently at the beginning. It's a very fascinating exercise. There are 15 chapters, and he mentioned some of the most interesting ones, but they are all commentaries by lawyers on some of the 700 judgments that Dato Seri has issued during his long service. Now, that's a very interesting exercise in itself. In some ways, it's a kind of handing over of the baton. That's how I see this process. And I was really encouraged by the fact that there are a number of rather young lawyers who are writing. I mean, this really did lift my spirits when I was thinking of young lawyers in their 20s actually reflecting on this body of judgments and really reading and interpreting them in very special ways. So when your partners approached you, with this idea, what was your initial reaction? I mean, I presume you were very enthusiastic to establish this kind of dialogue or this conversation with younger generations of lawyers. Am I right?
The book is a branch. I have to say the book is a brainchild of one of our partners, at the firm, Mr. Sarana Kumar, who became the editor of the book. Yeah, it is his idea to come up with the book, and his idea to come with the way the book is going to be written. Yeah, it won't be written by me, it will be written by the partners and the associates. Yeah, and it'll be on various themes under the Federal Constitution, freedom of speech, freedom of association, rights of property, rights of religion, yeah, rights of association, and so forth. Yeah, yeah. I am well. I am grateful and indebted to the partners and the associates for finding time and energy to write those articles. Yeah.
Was there a process in which you were able to read the drafts of the chapters of the books? Did they share those with you at
Yes.
all? Yes.
They shared me the drafts, yeah, to see, just to ensure that they are on the right track. Yeah, yeah, they interpret the judgment correctly. Yeah, yeah. But I give them a free hand, even to be critical of my judgment. Yeah.
I honestly, as an editor, I find this a really fascinating process because it's a genuine conversation, it's a genuine dialogue that Dato Seri is saying, okay, you have a relatively free hand to critique, to interpret and so on, but let's have a conversation so that maybe there can be a little bit of steering or a little bit of correction and so on. I would just like to emphasize out of the 15 chapters, I mean, there are some, for even those of you in this room who are lawyers, maybe your eyes will glaze over. I mean, tax judgments, you have to love tax law to be able to get into that, or property rights or so on. But look at some of the chapter headings. Let me just run you. The first chapter is called Good Governance. It's headlining the book right up front. And we'll talk a little bit about good governance in a moment. But also free speech. There's an entire commentary run around Dato Seri's judgments that pertain to or allude to or in fact directly refer to questions of free speech. A judge for personal liberty. And often in Malaysian legal discourse, of course, personal or individual liberty is often trumped by notions of collective or group rights. And we know even that's how much of the political and legal discourse has been done. How about this one? Native rights. This is looking at Orang Asli and East Malaysian indigenous rights to land, among other things. Not many judges are actually grappling with that set of questions. Judicial power. What does that mean? Judicial power. And finally, it ends with the notion of upholding the rule of law. So you can get a sense, I think, from my summary of that's fewer than half of the themes, that these are some of the most powerful sets of legal, and I would suggest beyond legal, social and political principles that can actually create or indeed break the good society to which I hope we all aspire. So beyond the issue of the individual legal cases that the contributors are grappling with, I mean, it seems to me that, Dato Seri, there are a number of key absolute principles that lie at the heart of all your judgments. And for the rest of our own conversation, I'd like you to reflect on each of those. Now, there are three. The first one is upholding justice for the happiness of the country. Happiness in that sentence is a very 18th century word. It's a very 18th century. It's actually even in the American Constitution, you know, this notion of happiness. But let's call it the well-being. Let's call it, you know, the good society. But the key word is, for you, Dato Seri, justice. What do you mean? I mean, for some people, you know, one man's justice is another man's injustice and so on. Sorry for the slightly gendered language. What's your sense of the just society in a Malaysian context?
A just society is where that first thing we must have a courageous judiciary, courageous judges who interprets the constitution and the law without fear or favor, who interpret the constitution in accord with its oath of justice. Yeah. Of course, justice, can be, in a way, can be subjective. What is justice to one? What might not be justice to the other? But it is, from me, it is justice in the way that I see it. Yeah, yeah. Interpret the law as it is without fear or favor. Yeah. It is easy to do justice on a fine weather. Fine weather. On the ordinary day-to-day case, is easy to do justice. But the real test of a judge is when he has to sit and judge a highly sensitive case, a highly political case. Yeah, a case, a common man versus the government. Yeah, and that's where the test is. Yeah, the test is. After 1988, the tragedy, there is a culture of fear, and there's the perception of the public that our judges are not really independent when giving judgments, and I don't blame them. There's some justification for that perception when we look at the way judgments are made out. Take for example the trial of Dato Seri Ibrahim, right? We know justice, the judgment found him guilty right until the federal court in the second sodomy, when we know the evidence is wanting, and that applies to the first sodomy as well, and even to the other, charge of abuse of power. So that's what happens. Something wrong? Yes, yeah. There was this culture of fear. Yeah. Can I be going to tell a story about a case where I did?
Absolutely. I think to illustrate the
Yes.
general point is actually very good.
The year was 2001. Yeah. How a judge will have to work the environment he's in. There were 4 Keadilan members. All were arrested. Dr. Mahathir was the prime minister then. 4 were arrested. 4 of them went to the High Court of Kuala Lumpur to seek writ of habeas corpus for their freedom. I think Izam Tianchua, Hishamudin Rais, and there's another one. I think Sari Sungim, I can't remember. I may be wrong. Yeah, 4 of them, and came before Justice Augustine Paul. They were all rejected outright. Application was thrown out of the window by the judge, and another 4 came to the High Court of Shah Alam. I was a senior judge then. A senior judge. Sorry, this story you can say about 5 or 10 minutes. Right? Okay. So I took 2 of them, Ghani Harun and Gobal Kishnem. I took these 2 cases because they are interlinked, and there's another one, doctor something I can't remember. Yeah, when I allocated into another judge. I do the allocation because I was a senior judge there. Right. The first thing that I observed when the case came up before me, we have issued an order to produce to the prison to produce them, but the two Gani Harun and Gobashana were nowhere to be seen in the court. So the lawyer, Mr. Sivarasa, stood up and say, my lord, my clients is supposed to be present, but they were not allowed to be present by the authority. So he applied that I make an order that they be produced. Okay, and then of course the Senior Federal Counsel from the Attorney General's chambers objected. They say, no security reason, we cannot produce them. So after hearing arguments, I make a decision. I said yes, they have to be produced before me. Why? Because this is their application, and they're making this application under their right under the Federal Constitution, Article 5. So to give full effect of the Federal Constitution, they have we must honor their right to be present. So I make an order that they be produced. So the representative of Attorney General says, oh, we don't know where they are. Those days, even where they are being detained is a big secret. We don't know where they are. I said, I'm sorry. I said, that is your problem, but I want to see them being produced tomorrow on Monday. But it was a Friday. On Monday, when the case was about to start, I got a phone call from the Chief Justice. He says, Hishamudin, could you hold on for about an hour? Don't start with the hearing yet because parties are now before the federal court. Yeah, the government wants to reverse your judgment for them to produce. I said, okay, all right. So 1 hour passed more. Then came the call from the Chief Justice, Tun Zaidin. He says, the federal court has upturned your decision. Yeah, so they can't be produced before your court. I said, okay, never mind. We'll hear in their absence. So I proceed in hearing in their absence. Yeah. Then I heard the submissions. Then come the judgment day. That's I think 30th or 31st of May. The last date of May. Yeah. And having read through the affidavit, the submissions, it dawned upon me that, the case for the government in detaining them is weak. And I would say, I feel that the detention was in bad faith. It has got to be, they were denied of seeing the counsel. Counsel tak boleh jumpa. From day one sampai, they were denied as family access, right? Yeah. And they were inbuilt safeguards under the ISA, within 24 hours before an inspector, after that 48 hours before the ASP, after the DSP, right? These officers are supposed to be the safeguard, but they just grant the extension as mechanically, as a matter of course, and that goes against the spirit of the ISA. And there are so many other issues, and I made a decision that they have to be released. Yeah, that's my conscience. Yes, yeah, but it's not that easy. It's not that easy, I'm also human because there's a culture of fear that hangs away. Yeah, and I'm going to make nobody set free Mahathir's prisoners. Yeah. Leave it in this room, okay? Yes. Yeah. So I'm going to do something that will, be a bombshell. I'm going to set them free. Okay. So I prepared my judgment, 20-page judgment, and on the day itself, I read out the judgments in open court. In the morning, the court was empty. I read the judgment in an empty court. Yeah, except why it was empty? Because everybody knows the judge will just throw it out. The judge will throw it, yeah. The judge will just throw it out. So, but I delivered a different judgment. Judgment said, I read out the reason why, I think it's mala fide and all that. Then I make a judgment. I said, please produce them before me at 3:30 p.m. to Friday. 3:30 p.m. this afternoon. I will make a judicial pronouncement of their liberty under Article 5 at 3:30. So again, the Federal Council from Intelligence Chambers stood up and said, "My Lord, we don't know whether we could comply with your order. We don't know where they are. Again, we don't know where they are." I said, no, that's your problem. I want to see them before me at 3:30 p.m. so that I can set them free. So it's a Friday, went back for Friday prayers and all that. So when I came back to court in the afternoon, the scenario was different. There were people all over the place, The words have spread around, yeah. There's a crazy judge around here, yeah? Right. So I can see, and there were FRU, yeah. As Shah Alam Court, I got to drive away. There were FRU along the way, lining up the road. And as I entered the corridor to my chambers, there were personnel which I believe are special branch officers, yeah. So 3:30 sharp, I went up on the bench, and there were helicopters also swirling in the sky. Full of drama, right? Yeah. The court was packed this time. Morning, empty. Afternoon, the court was packed. To see, right. The first thing when I got on the bench is to see, did they comply with my orders? I looked down from my bench. Yes. There were the two of them. There were two. Yes. Okay. Otherwise, I'll be in conflict with the police. I'll have to cite them for contempt, for going against my order. So they were there. So before I could make a formal order, Mr. Malik Imtiaz stood up and said, my lord, we all sense that the presence of the police in the courtroom, uniform and uniform, yeah. We anticipate a rearrest. Immediately, my client said, put outside this court with assent, yeah. So I pray to the court to make an ancillary order to the police not to rearrest them, at least for the next 28 hours after they left the courtroom. Okay, that's the application. I look at the Senior Federal Council. Well, what have you got to say? Senior Federal Council says, no. We objected, yeah, to refrain the police from rearresting is amount to issuing an injunction against the government. They said, oh, that's not possible. Well, I said, I have the powers under Section 25 of the Code of Judicial Act and Item 1 of the Act. Of the annexure, I have the powers, right? And the reason why, so he said, at least give them 28 hours for at least allow the detainees before they are rearrested again to meet up with their families who are on the way from the north. Yeah, let them have a chance to meet up before rearrest. I said, okay. So I make an order that the police not to rearrest them within the next 28 hours. So with that order, the special branch and the police, they all back off. They didn't arrest. And they were never, even after the lapse of 28 hours, they were never rearrested. Yeah. So for that compliance with the court order, I have to credit the police. Can I have another 5 minutes?
Sure.
The aftermath of that judgment, there's a weird story. So after I gave the judgment, tomorrow I was on leave. I went to Alostar to attend a wedding, and there was some report about the judgment in the newspaper, and some remarks by Dr. Mahathir and all that about my judgment. And I got a phone call from my mother. Okay, my mother was crying. He says, "No, son, you're going to lose your job." Yeah. Well, I told my mother a white lie. I said, no. They can't dismiss a judge. I'm protected under Article 125 of the Constitution. I know it's a white lie, because if the government wants to dismiss you, they can dismiss you like that, like what they did to Tun Saleh Abbas. Yes. Yeah, but just to appease my mother. Then, of course, yeah, there's the wedding. And then I went back to my office. Okay, when I returned to work, the first thing was that my secretary came to see me. He says, "Josh, during your absence, a special branch officer came to see me." Yeah. He says he wants your biodata. Yeah. And he said, I lied to him. I said, I don't have your biodata. If you want, you go and see the senior sessions court judge there downstairs. And off he went. Okay. Well, I lost a heartbeat. I miss a heartbeat. Police coming, snooping around. Yeah. Now, are they after my blood? Right. In the afternoon, the senior sessions court judge came to my room. He says, again, he says, "Josh, in your absence, the police came to see me and asked for your biodata, and I asked him, what is it for?" Police officer said, "For the protection of the judge." For the protection of the judge. Then senior session court says, he asked the officer, "Protection against what?" "Oh, his ISA judgment. Then the session court judge says, "What's wrong with that judgment? Everybody likes the judgment." The policeman answered, "But not UMNO youth." Not UMNO youth. See how politics comes in. Yes. So he asked me, is it okay, Josh? I've given him anyway. Well, I said, you already given him. What can I do? Well, yeah. So, of course, that's the story, the aftermath. But well, I felt a bit disturbed. Well, I think who won't feel disturbed when the police came snooping, isn't it? Yeah. Were they up to something mischief? Okay? Yeah. Checking on me, checking on my income tax and all that. Yeah. They could make the case or something. Yes. So, but after that, nothing happens, and that was in early June then. Yeah. But equally on a Friday, the ICA decision was on a Friday, but in December, equally on a Friday, on the 14th of December, I got a transfer order from the High Court, the Chief Judge number 1 in High Court of Shah Alam, to become a second in judge in the Dagang Division in High Court of Kuala Lumpur. Are these two events connected? Is everybody's guest? All right.
Everything seems to happen to you on Fridays, So we don't say, thank God it's Friday, So, I think the anecdote was excellent, because I asked this simple question about the principles of justice. But of course, the principles, justice is a blind goddess, and we have all these principles, but it runs into the hard nose of realpolitik. And it's not just confined to Malaysia. I mean, any of us will know, with even a summary knowledge of what goes on even in other jurisdictions. So the two other elements that really stand out in the book, let me just conflate them for the moment. The first is the absolute centrality of the Federal Constitution. And in fact, there's this notion of the doctrine of basic structure, which is actually detailed by you and by a number of the so give us a sense in which the upholding of the Federal Constitution is absolutely central to your idea of justice and the good society. But also equally, the Federal Constitution should be, in my view at least, a living document. I mean, it's not something, preserved in an ossified way in August 1957. It has to be a living document that also reflects the changing contours of society. So would you give us some reflections both on the centrality of the Federal Constitution, but also perhaps even reflect on ways that it may be subjected to reform or change?
You heard about the so-called the doctrine of basic structure of the Constitution. You may all be asking, what is it? Okay, let me explain. There is an Article 159 in our first Constitution which gives powers to Parliament subject to certain procedure, for example, two-thirds majority in certain cases with the consent of rulers to amend the Constitution, Yeah. In other words, if we follow literally Article 159, okay, as long as Parliament comply with the procedures set forth in Article 159, Parliament can amend the Constitution in any way it did, so that even if Parliament amend the Constitution in a manner that is no longer reflects the original Constitution, if we were to take Article 159 in its literal form, it will still be valid. Yeah, but to those who advocate the doctrine of basic structure, the answer is no. You can comply with Parliament can comply with Article 159 of the Federal Constitution to amend, but there's a limit to your powers of amendment. You cannot amend the Federal Constitution so that it changes its character. Basic character, you can never change. Right to fundamental liberties, you can never take it away, even by two-thirds majority of Parliament, even by strict compliance with articles, you can never take fundamental liberties. And for example, in other words, you cannot take the federal system of government, right? You cannot take away constitutional monarchy, yeah, and you cannot remove, for example, Malay as the national language, or Islam as the regional federation. But if Parliament two-thirds majority wants to turn Malaysia into an theocratic Islamic state, that the doctrine of basic structure will not permit it, because that goes again the basic structure that we are a secular state. I take it that we are a secular state, but of course some lawyers might not agree with me. But to me, notwithstanding Article 3, we see Islam Federation, we are a secular state, not an Islamic state, because we have Article 3, Clause 4, which says, in the practice of Islam, yeah, must be in compliance with the provisions of the Federal Constitution. Yeah, so Islam in this country cannot be practiced in the Puritan form. Yeah, Islam in this country must be practiced in line with what has been prescribed under the Federal Constitution. Do I have a complete answer the question? Or
Yeah, no, it's really interesting. Notwithstanding 159, I mean, there were many, many years, indeed decades, when Barisan effectively did have a 2/3 majority. Was there ever a moment, political moment, when you actually feared that the political leadership, parliament, if you like, would actually overturn the basic structure? Were there moments of crisis, maybe after 88, particularly?
Yes. That was during the reign of Tun Dr. Mahathir. He wanted to emasculate the judiciary. He was unhappy with some of the judgments. Then, Yusuf Abdul Qadir was still on the bench. Yeah. Courageous judges, yeah, upright judges. And they've made good, courageous judgment. Like the journalist involving Beltherson, and the other one was a case of Yap Peng. Yap Peng, there's a provision. They put the provision, in the criminal procedure code. If the public prosecutor, Attorney General, wants a particular case to be heard from the Sessions Court to the High Court, the Sessions Court must transfer it to the High Court. There's no discretion. So, in the case of Yap Peng, that provision was challenged. They say that takes away the judicial power of the judiciary. That must, judges must be given the discretion on merits, whether to transfer or not. So, took up a challenge, and the party challenging won. And so, that Dr. Mahathir, and they moved an amendment to the Federal Constitution. Amendment to amend Article 121. The aim is to remove judicial power from the judges. Yeah. He goes on to provide, Article 121, provide that the high courts and the superior courts shall only have powers to the extent as provided by federal law. Yeah. If it's not provided by federal law, you don't have the power. That was the intention. Yeah. So some of our judges after that do subscribe to that. Yeah. So, but that was a move to take judicial power and to emasculate the judiciary. And that was the perception then. Yeah. Until the case of Semenyih Jaya. I think 2019 something. The case of Semenyih Jaya. In Semenyih Jaya, it's about land acquisition case, but never mind about that, about the details. In Semenyih Jaya, the federal court held that although the federal constitution was amended, although Parliament by 2/3 majority amended Article 121 in accordance with Article 159, but nevertheless, to us, that is contrary, taking away judicial power, and that is tantamount to going against the doctrine of basic structure. And the federal court says that amendment is a nullity, is of no good, no validity. It's a very bold judgment of the federal court. In the case of a landmark case, it is called Semenyih Jaya. And that view was upheld subsequently by the case of Indira Gandhi, and then by another case called Alma Nudo. Yes. And then recently, yet by another federal court quorum, a case of Dinesh. Yes. Yeah. So back to your question, yes, there was an attempt. Yeah. But the court fought back. Yeah, and reasserted its authority.
Absolutely fascinating. One of the great values of the book, by the way, is that some of these very recent cases, up to 2022, are actually reflected upon in the book. Yes, right at the beginning. So the third key principle that you speak which informs almost everything that you've written, is of course, to uphold judicial independence. You've already alluded to it on a number of occasions, and that does mean some insulation from the encroachments of the legislative branch of government, parliament, like you said, but also the executive branch. Now, as a former political science professor, I'm going to make this very clear and obvious statement. If you look around comparatively, around a number of different countries, societies in the world, there has been a general trend in many, if not all, for executive overreach. By that we mean the executive branch has tended to accrete more and more powers unto itself. And given it, you know, we can talk about a zero-sum game, the more powers that the executive have, well, it follows ergo that diminishes the powers of either or both of the legislative and the judicial arms of government. And that's clearly has been the case, if we read it politically, not legally. In Malaysia, Mahathir was the past master of the executive, the PM's office, accumulating greater and greater powers. How do we defend against that kind of political encroachment, where the executives take more powers? And look, we don't need to look at Malaysia. We see what happens even in a country that sees itself as a bastion of liberal democracy, the United States. We saw in the 4 years of Trump what happens when you pack the court. And in the particular system, when you're applying extremely conservative judges who are appointed, by the way, around the age of 50 years old, who then serve for life. And that means you have actually created a terrain, a judicial terrain, that is going to last for decades. You know, forget the particular individual president. So it's a worry for me, I mean, as a political scientist, when I look at executive overreach in a whole raft of cases. And is there any possibility for pushing back, if you like, the kinds of executive powers that have been accrued, I would say, at least for the last 25 years or so, not least during Mahathir's multiple periods in office? Dr. Sri, your reflections on how do we sustain judicial independence?
We need courageous and independent-minded judges. I keep on saying that. But the question arises, how do we get these judges? How? Yeah. Well, one of the methods is we focus on the way judges, if we want an independent judiciary, we must study how are judges being appointed. Yeah. There was a time where judges are appointed by the Chief Justice. Yeah. There was no JAC, Judicial Appointments Commission then. When I was appointed a High Court judge, there was no Judicial Appointment Commission. I was just appointed by the Chief Justice then, Tun Hamid Umar. But when I was appointed as Court of Appeal, I was the first batch to be appointed by the JAC. Yeah. So we need to look from the angle of how judges are appointed to ensure that judges are independent and courageous. So we have the JAC. We have already JAC. I think the Act is 2009, consists of 9 members. 5 are judges and 4 are called the 4 eminent persons. Out of the 9, 4 are ex officio. The Chief Justice, President of the Court of Appeal, the Chief Judge Malaya, Chief Judge Sabah Sarawak, they are ex officio, automatically become members. And then there's another judge, a federal court judge, but he's appointed by the Prime Minister. And then the eminent persons, yeah. 4 eminent persons, they are also appointed by the Prime Minister. We need to study the structure of the JAC to look at, can it be improved? Are we contented with the JAC? Personally, you ask me, I see the Judicial Appointments Commission needs to be revamped. Only, remember, there are only 9 and 5 are judges. I would say it's judge heavy. It is judge heavy, yeah. And then out of the 4 eminent persons, when I was there, I was an ex-judge. Justice Linton was an ex-judge. Judge Ma Weng Kwai was an ex-judge. Again, judges. Yeah. I think we should study the JAC of other countries as well. A good example with the United Kingdom. There are 15 members. I advocate for the expansion of the membership so that there will be the representative in the commission, there'll be what I call diversity. We are a multi-religious, multicultural, and multiracial society. So it must reflect, our pluralism, right? And then it must also take into account other interests. The Bar Council, the Attorney General's Chambers, the academia, and other stakeholders, Yeah, so that present consumers, that represent the environment, okay? Yeah, a few to represent other interests as well. In the UK, it's 15. In UK, it's 15, and you might be interested to know that in the UK, I think many members are not appointed by the Prime Minister. So we are appointed by the Prime Minister. So the Prime Minister appoints, a man of his color, I mean, so to speak, like, yeah.
Well, it's a perfect example of the executive overreach. On the surface, having the JAC looks like an independent move. But just look at the simple arithmetic. The PM holds 5. I mean, do the math, as they say in America. 5 versus 4. No matter the independence of the actual ex officio members of the JAC. So I think clearly both expansion and a reflection of greater diversity, should be the least kind of reform that we should expect.
And can I add?
Yes.
The Prime Minister appoints, there is no criteria how he appoints, and he can remove the members at any time. So the members of the commission has got no security of tenure. Yeah. In the UK, majority of the members are those who apply to be members of the JAC. You can apply in UK. You can apply, and the government appoints a committee to evaluate the applicants, whether he or she is fit to be on board the JAC. And the majority in UK, of course, there are a few judges, as of right, they are there, but the majority are those who are there by virtue of the fact that they applied and they are appointed by this particular independent committee. Yes, of course, they have got a criteria, yeah. And interestingly, in UK today, the chairman of the JAC is an applicant member who applies. Yeah, he's not an appointed member. Yeah.
So a lot to chew on. I think it's about time we opened up the floor. I mean, Dato Seri, you've taken time to illustrate some of these points, but I think the illustrations you've given are incredibly illuminating as to, even a judge who has deep set of principles, basically a progressive activist reading as a lawyer, can come up against the cold steel of realpolitik in this country and indeed elsewhere. Let's open it up. I do hope that there are reflections and contributions from the floor. We'll keep them concise, precise, and and if you just reveal yourself, who you are, in case you're special branch. No, this is not the time to go all shy and quiet. Come on, you know that. How do you? As if you haven't spoken enough yet.
One of the big issues is the independence of the prosecutor, and the whole way in which the prosecution department is also controlled and seem to be able to do selective action. I wonder whether that one area also needs to be carefully examined and changed for the country. I want your thoughts.
Do you need to use this? Yeah, okay. Right, yeah. Yes, Dato Seri. In our country, at the moment, the Attorney General doubles as a public prosecutor. Yeah. As Attorney General, he is the legal advisor to the government. He drafts laws for the government, and he goes to court to defend the government. But at the same time, he also prosecutes. Yeah, yeah. No prosecution will ever take place without the sanction of the public prosecutor. But today, in most countries, the public AG office of the Attorney General and the office of prosecutor has been separated. Yeah, in most countries, especially I'm only in most countries, quite in a number of countries in the Commonwealth. Yeah, like Canada, UK, Australia. They have a separation now. Yeah, the prosecution is removed from the Attorney General, and a new office is being created. It's called the Director of Public Prosecution. Yeah. So the Attorney General is only left to do the other work as legal advisor to the government, drafting laws, and and defending government in civil cases in courts. And this is a healthy development, so as to, because the closeness, proximity of the Attorney General and the government of the day in their day-to-day work. And so there's always the perception, will the AG really be independent? Whether to prosecute or not to prosecute, whether to prosecute Najib or not, right? Yeah. Yes. So I think the separation is on the cards. I think you must read in the news media that the Minister of Law, Azarina, has called for a meeting, with a view to draft laws to have this separation. Yeah, I hope that will be a reality as soon as possible. Of course, at the moment, I think there's a lot of perception about selective prosecution. Hey, why so and so? It's so free, to so free to say bad about other religion, to say bad, and this guy, he just said a little bit and he got prosecuted. That's the perception. So I think it's high time that the office to office is separated, and it's high time that we get rid of this perception that in this country selective prosecution exists. We mustn't have these feelings. It's not healthy.
It's when I joined Chambers, it's one of the things that absolutely shocked me was the deep concentration of power in the person of the Attorney General. Chapter 3 of the book is very judiciously titled Taming the Powers of the Attorney General. And the young scholars reflecting on this are picking up on the number of cases that Dato Seri has actually, addressed this particular problem. Look at the UK. I mean, I'm not saying the UK is a paragon of anything or everything. Well, they go through prime ministers even faster than we do. But Keir Starmer, the leader of the Labour Party, was the director of public prosecutions, and completely separate from. He was not under the patronage of Tony Blair or Gordon Brown or any other office. He served the office of Director of Public Prosecutions, and that's how it should be. I mean, at the very, very least. More reflections and questions or contributions from the floor, please. Penang people are not usually this quiet, Dato Seri. Yes, sir.
So, Dato Seri, thank you. My name is Lee. I'm in by individual capacity. What relevant provisions of the Federal Constitution were amended pertaining to the territorial integrity and sovereignty of the country to enable the inclusion of Sabah and Sarawak within MA 63, and subsequently 2 years later, the exit of Singapore from the Federation? Thank you.
Really not. Can I have your name again? I'm not clear.
Lee. No way.
Will you look? Yeah, just say the question again, very, very, very nicely and concisely.
Yeah, pertaining to the territorial integrity and sovereignty of the country, I wanted to know more on the relevant provisions of the Federal Constitution that were amended to include Sabah and Sarawak under MA 63, and 2 years later for the exit of Singapore from the Federation. Thank you.
Okay, I get your question. What is the position of Sabah, Sarawak as a state within the Federation? Right. The Federation exists in 1963, right? 63 out of the Malaysia Agreement. The parties were the United Kingdom, Singapore, Federation of Malaya, the British colony of North Borneo, and the British colony of Sarawak, right? Yeah. So they entered into an agreement. The British government wants to let go of Sabah and Sarawak. So they were feeling where is best to park Sabah, Sarawak, yeah, and Singapore. So the idea came. I think our Tunku Abdul also contributed to this idea. Why not have them federated with the Federation of Malaya and call it Malaysia with Singapore, Federation of Malaya, Sabah, Sarawak. Sabah was then called British North Borneo. Sarawak was a crown colony, and Brunei as well. But Brunei was not keen with the idea, and they backed off. So leaving Singapore, Federation of Malaya, Sabah, and Sarawak. And then what happened was 1965, Singapore broke off for political reason. So leaving behind Federation of Malaya, Sabah, and Sarawak. Not what I said. Federation of Malaya, Sabah, and Sarawak. Yeah. So the idea within the Malaysia Agreement is that there are three separate entities. Yeah. Sabah and Sarawak stand on equal footing with the Federation of Malaya. Not on equal footing with the state of Kelantan, Negeri Sembilan, and all that, no? But equal footing with a country called Federation of Malaya. That was the understanding. But what happened was I think it happened in 1976. Our constitution was amended to make Sabah and Sarawak on equal footing with the other states. Yeah, but if you were to read the handset, when the constitutional amendments were introduced in Parliament, not a squeak from the MPs of Sarawak, not a squeak from the MPs of Sabah. Every one of them went along happily. Yeah. Only until lately, they start murmuring, hey, why are we being made equal as to the other state? Yeah. When we enter as on equal footing with the Federation of Malaya. Yeah. So that's how recently, with pressure coming from these two states, the government of the federal government relented and said, all right, we will amend so that to put back where Sabah and Sarawak as they're supposed to be envisioned under the Malaysia Agreement of 1960. Hence, that's why we have the recent amendments. Yeah, I'm sure you have read those amendments. Right, yeah.
It's a fascinating topic because the 76 decision to change the status would have been an attack upon the basic structure doctrine of the Malaysia Agreement 63. That's one thing to say. But also politics again. Those are vote baskets, yes? I mean, no matter what, those are vote baskets. Sarawak and Sabah need to be delivered to whoever wants to take power in Putrajaya. So I think this has become far more. You talk about perception 2 or 3 times. Perception matters in these things. So the perception that, to use technical language, we've been screwed. That's a technical term, by the way. That Sabah and East Malaysia has been screwed by Peninsula. That, even though these are extremely resource rich, the resource richness has been a curse because most of that wealth has been channeled back to Peninsula and through to us here. I think this is a subject that I hope Anwar will actually see to that he makes a priority. The relationship between Peninsula and East Malaysia, which has been extremely badly handled by, of course, because they're Peninsula-centric parties. UMNO has very little representation in East Malaysia, if any, the same needs to apply as well. Otherwise, everything will be done by horse trading. And when you have somebody like Taib holding, I'm going to deliver you 40 seats in Parliament, that becomes a huge leverage over the entire political system, and you can get held hostage. So, you had a question. There was a question here and then a question there. Lime green. No, lime green. I thought you had a question.
Me? No.
Yes. Oh, okay. I thought you were waving to me. It's because you like me.
Oh, yeah.
It's fine. I like you too. Yes, sir.
Dato Seri, could you share with us your thoughts on the AG's push to have a Malay language version of the country's Federal Constitution as its authoritative text?
I'm not for it. Yeah. When the Federal Constitution was promulgated in 1957, it was drafted in only one language, that is the English language. When it was drafted in 1957, there was no Bahasa Malaysia version. There's only one version. And the courts have been interpreting the Constitution based on the English language. Yeah. This translation was done by the Attorney General's Chambers. It must be before your time. What? Yeah, I was in the drafting division. It was drafted by officers of the Attorney General's Chambers, and the translation was done based on what the officers who did the translating things, it should be, yeah. But is that the right translation? If the translation is not right, yeah, it's not right. How can it be? How could it be the text to be used by the courts, right? What if the translation is wrong? Yeah. Those who did the translation of the English text, many years later, they themselves are not experts on constitutional law. So to me, it's a no-go. Yeah, it's a no-go. Yeah, it's a non-starter. I don't know why the AG has come out with such a suggestion. Okay, take the case of the word parent in Article 12. Okay? It says parent. It says parent, right? And there have been translation, a dispute how to translate parent. It's singular, parent, singular. Yeah. In the case of Subhashini, the federal court interpret parents to mean either mother or father. Not mother and father, interpret to mean either mother or father. So if the father has become a Muslim, yeah, bring the children, rush to the Jabatan Agama Islam and have the children converted to Islam. Hey presto. And they became Muslim behind the back of the mother. Mother tak tahu. So such a scenario doesn't make sense. So, but that's how Subhashini, the federal court interpreted the word parent in Subhashini. Then, a few years later came the case of Indira Gandhi. In Indira Gandhi, an enlightened federal court interpret parents. Parents mean both mother and father. Yeah, both mother and father, because the rationale is that is in consonance with the concept of justice, because both are guardians of the child. So so you need the consent of both for any move towards conversion. Okay, but if you read the Bahasa Malaysia text, how was it interpreted for parent? Dia tak kata ibu dan bapa. Bahasa Malaysia text says it can be converted with the consent of ibu atau bapa. Itu atau. So do you know now what's the ramifications of if we agree with the Attorney General to have it in Bahasa Malaysia? So ibu atau bapa will be the order of the day. Yeah? And there goes Indira Gandhi. There goes Indira Gandhi, and we bring back Subhashini. So I'm not in favor of it. Yeah.
Dato Seri, you made yourself very clear in a very principled way. You know, they said Roger Casement was hanged in the First World War on the comma. There's a famous judicial case in Britain because he was he hanged on the comma. But you know, these are not just small technical things. Look, I worked in chambers. The quality of the older generation of officers in terms of English language, like yourself, absolutely brilliant. And some of the younger ones who've been more exposed or maybe have also gone away to study. But the powerful middle-ranking officers, there was an inferiority complex. There was a sense in which, you know, my England not powderful, you know, cannot follow. And so ergo, let's change, you know, but without the kind of, I mean, I'm a very close friend of the national writer laureate, Muhammad Haji Saleh, very, very dear friend, but also a wonderful translator. And he speaks very well to this deficit in terms of capturing not merely as Google Translate would give it to you, but a sense in which the law is a living, breathing thing, organically emerged in a particular context, and that language itself, needs to be treated with the kind of, as you said, language denotes, it connotes, it has meanings, and so on. Okay, Kibeng is pointing pointedly at his watch. I think there's a party, Kway Tiao party that's planned for afterwards. So let me maybe take, if there's one more brief, concise question, I'm very happy it's you. Sorry, Kibeng.
Dato Seri, I'm Devaraj. I'm not legally qualified. A thought came to me just now, and that is this. The legislature makes laws. Has the judiciary a role to, when it is passed, of course, to look at the law and say there are many flaws in that law?
Judicial review, really, isn't it?
Well, the role of Parliament, because of the separation of powers concept, we have the judiciary, the executive, and the legislature. The role of Parliament. I got your question right. The role of Parliament is to make the laws, and the role of the judiciary is to interpret the laws. Yes. But in interpreting the laws, the judiciary will have the power to say that the law doesn't make sense or the law is unjust, and to interpret it the way that there is justice. Yeah, but the judiciary has no power to amend the law. We have no power to amend the law. We have no power to say, go back to Parliament and have it amended. No, we have to interpret it in the best manner that we can to give some sense to the law. Yeah, and if the law is bad, the judges will just say the law is bad. We do not make couldn't make head or tail out of it. Yeah, and at times I do say that. Yeah, but do I get your question right?
Yeah.
Or it doesn't answer fully? Yeah. Do I got your question right, or have I fully answered your question?
Not quite related.
Yeah.
Just now the states was mentioned, and from what I see, the appointment of judges is based either or based on what their perceptions are, whether they're conservative or democratic and so on. So so I always was thought that the judge makes a decision on the law
Yes.
and the facts.
Yes.
But whether you're conservative or not conservative is not part of that. But yet you see in the states the conflict going on for years, and I don't see how they could be an example for us in any way.
Right. You mentioned the word conservative. Well, we have to take judges as they are, and judges are human, so they are influenced with their training, with their background. In the early years of our independence, our judges are very conservative, are very pro-government. But It's not because they are dishonest. No, they are not pro-government because they are dishonest. They are pro-government because the majority of them, they come from the Attorney General's chambers. They're people like me. I come from there. Yeah, yes, yeah. So there is this mindset, deep behind us, to be a bit of a pro-government, not because we are going to be dishonest, but because of our background. Yes. So judges being conservative, I would say even Tun Sofyan was a conservative judge. He wasn't that innovative, yes, but that's how it is. We have to take the judges based on what they are being human. But we have, activist judges of late. Tunku Maimun, Justice Nalini, Justice Haminda, they are all activist judges. You see how, they're very bold and courageous. They gave in the interpretation, they gave a different color to the Constitution. Yeah. Thank you. Yeah.
I think there's a really good question maybe to conclude with. And one of the features of the book is a lot of the commentaries are based on dissenting judgments that Dato Seri actually made. Now that's very, very interesting, because as he said, there are complex reasons of personality and politics and background that create the human being called the judge. They are not God, by the way, in case you're under that illusion. And so the dissenting judgments are really, really fascinating. Look, I worked on the Pulau Batu Putih case, Singapore versus Malaysia, over the lighthouse and so on. We lost the main lighthouse, but we didn't lose 15-0 in The Hague. I was there. We lost 11-4. But of the 4 dissenting judgments, 3 of them wrote long counter opinions, which have actually gone a long way to questioning the original majority decision. There happen to be 3 very senior judges and whatever. So I think it's healthy that there's dissent, and that dissent can be engaged with in the way that these young lawyer scholars have done in this particular book. Of course, that's me, as they say, bigging up the book and making sure you buy it. You can't leave the room. Special branch have a stopper on the door. You can't leave the room till you've purchased at least 1 copy of the book from this delightful young lady. Dato Seri, I want to leave the last word with you. You've mentioned her name a number of times, Chief Justice Tun Tunku Maimun. We were all, if you weren't also aware, you were very aware at the federal court's judgment in the case of Najib Razak. Some of you may have been surprised. Some of us were not surprised. We knew some of the personalities there. Dato Mary Lim, very close friend of mine, was there on the federal court. You feel really quite optimistic, don't you? I mean, maybe more optimistic today than possibly at any other time in the last few decades. Maybe just leave us with a sense of that, why that optimism is grounded in a sense of the judicial and political changes that we're living through right at this moment. We send everyone home happy.
Well, we must consider ourselves today as fortunate because we have Tunku Maimun as the Chief Justice. And he's a very enlightened and courageous judge. And you were to read some of the federal court judgment, there are quite a number of judgments where, although Tunku Maimun herself is the Chief Justice, she is the dissenting judge. The dissenting judge. In other words, she gives the panel a feeling of freedom. I'm the Chief Justice, okay? I'm the Chief Justice. You don't have to agree with me. If you feel that your judgment ought to go the other way, you are free to do so. Talking about dissenting judgments, I think I have given the most dissenting judgments among the judges. Yes. And I think a judge will have to be honest with himself. Yeah. Have to be honest with. If he feels he could not go with the majority, he shouldn't go with the majority just for the sake of expediency, or the chairman dah cakap macam kita ikut sajalah. No. The judge has got to be honest. He's the officer of office, and he must be honest also with the litigant. His judgment, the dissenting judgment might be for the minority. The party does not win, but it gives comfort to the litigant that at least one judge sees it the way I do. Yeah, you see? Yeah. So judges must be independent, must be courageous and brave to dissent from his brother or sister judges, because that is the hallmark of an independent judiciary. Thank you.
Dato Seri, do you have any plans to write a memoir with the title The Dissenter, obviously, Any plans? Because if not, I'm encouraging you to do so. We need these rich, exemplary lives, and for the generations that follow. Please say yes.
Yes, but not at the moment when I'm fully retired. I'm not fully retired yet.
I can't imagine the day when you will be fully retired, so whatever. Would you engage me to be your editor?
Pro bono.
Wow, now, okay. Okay, this is being recorded live, so I better be extremely careful what I say. We have an agreement. Let's hope it's not like the 1963 Malaysia agreement. Okay. I believe Kibeng wants to, we're going to do a little formal moment. We're going to have a moment to formally launch the book here in Penang. Thank you. They're conspiring. Okay, and while saying nice things to him, so that's okay. Listen, it just leaves me to say my own thank yous, okay? First of all, thank you for coming out on a Friday evening. I'm sure there were many contending things for your attention, but you came. Nearly everybody stayed, which I think is a tribute, in fact, to the evening that we had. Thank you for bringing the books, and good luck with the sales. I've done my best to pitch the book to them. Kibeng, thank you very much for hosting this event. Anwar, thank you for your eloquence in telling us yet again about the story of the crooked magistrate. But it is a good story. But above all, please, can you give a really warm Penang thank you to Dato Seri Hishamudin Yunus. Yeah. And sorry, I should also say, and thanks to the Penang Institute staff for always doing a marvelous job and capturing this for posterity, including the handshake at the end.